Okay, I did this video about the traffic incident involving William McNeil Jr. Now, in the comments section of that video, 3 names kept getting mentioned: the Officer Tatum, LackLuster, and the lead attorney. LackLuster, for instance, says that police need probable cause to pull over motor vehicles.
These 2 facts eliminate all probable cause for the entire stop, which means everything that occurs after this moment was unlawful.
The standard is actually reasonable suspicion, but I'll explain to you why he's wrong. Then I'll jump into why the lead attorney is wrong when he says this.
That's what the spirit of the law says. That's
that's what the spirit of the law says. I will tell you, and again, none of this is taking shots at Officer Tatum. Excellent content creator. Say, oh, well, that's the spirit of the law. That's what the legislature surely meant. I'm sure that if the legislatures had more time, then they would have said, they would have clarified, they would have put in writing. Whenever you hear someone say it's the spirit of the law, you know you got it.
The lead attorney is wrong, legally wrong, and I'm going to prove that with actual case law. So we got a long technical video coming up. Let's get into it. All right, so first, let me give you a little background on the case. This is William McNeil Jr., and he was pulled over by police for not having his headlights on in inclement weather. And officers also said they observed him driving the vehicle without a seatbelt. Now, because of those 2 traffic violations, McNeil's vehicle was pulled over, and officers asked him for his license and registration.
Is there a reason why you're popping the door open like that?
I don't have a window that works. Is there a reason that you're pulling me over?
Yeah, absolutely there's a reason why I'm pulling you over. For one thing, inclement weather, you don't have your lights on. 2 things, you're not wearing your seatbelt.
It's daylight.
3,
I don't need the lights. And it's not weather. It's not raining.
Oh, this is inclement?
It's not raining.
Okay, I'm not arguing with you. I'm telling you why I'm pulling you over. Give me your driver's license, registration, proof of insurance.
No, call your supervisor. Why?
Excuse me?
Call your supervisor. Why did you pull me over?
77, 35. I'm a proper driver. I've already told you.
Why did you pull me over?
Step out of the vehicle.
No.
Step out of the vehicle.
Now, first we're going to deal with LackLuster, because LackLuster believes that this whole stop is unlawful because the police did not have probable cause to pull the vehicle over.
He claims that McNeil's headlights were not on and that he was not wearing a seatbelt. But the suspended license and having marijuana are facts that were only revealed as a result of an unlawful traffic stop conducted by JSO. The probable cause, as stated by the deputy, was that his headlights weren't on. But again, the law states during any rain, smoke, or fog, none of which were present. And as to the claims of not wearing a seatbelt, the officer transmits over the radio that he didn't have any details about the occupant or occupants of the vehicle prior to McNeil opening his door.
Yeah, Florida 24 Bravo Echo Charlie Whiskey on a silver Kia unknown occupants.
These 2 facts eliminate all probable cause for the entire stop.
So there are 3 rapid fire problems with this analysis that we're going to have to debunk. Number 1, probable cause is not necessary when officers are employing a traffic stop. The standard is reasonable suspicion, and we're going to talk about that in a sec. The second thing he mentions is about it not raining at the time the car was pulled over. That too we're going to have to address, and we're going to address it also a little later when it comes to our boy, the lead attorney. And then lastly, he says that because the officer said there were unknown occupants in the vehicle, that means the officer did not see Mr. McNeil without his seatbelt at the time. So we'll address each one of those in kind. First, let's talk about the aspect of whether it's raining at the time this car was being pulled over. I'm going to say this is probably one of the worst arguments I hear about this particular case. LackLuster believes that since it's not raining at the time the car was being pulled over, that doesn't mean it wasn't previously raining when the car was driving down the road. Now, it is extremely likely, meaning that during the rain, the officer observed this car driving without its headlights on, and then when it was able to be pulled over, the rain had stopped.
It wasn't raining. Look at this video. This is fresh rain droplets still hanging onto his vehicle. If somehow it wasn't inclement weather, which means it wasn't raining at all, you wouldn't still see rain droplets on his car.
So LackLuster's assumption that because it's not raining right now at the moment the car is stopped means that it wasn't raining when the car was driving down the road is idiotic, just to say the least. It's just idiotic. But you're going to see a lot more people make this argument, but it is a dumb argument. Now, what happens if the officer said, I pulled you over for speeding? Would the argument be, well, hey, look at the body cam footage. The car is not speeding at that particular time. So that means he wasn't speeding at all. You would automatically come to the conclusion that, hey, he was obviously speeding before when the officer observed him, and now the officer's pulling him over and trying to issue a citation for that observed speeding in the past. This is not hard, people. Now, we're going to have to tackle this issue about it raining and during the rain when we talk about the lead attorney, because he's totally wrong about his analysis on this. But now let's continue with LackLuster, because he also says that because the officer said there were unknown occupants, that automatically means that he didn't observe the driver without a seatbelt.
Echo Charlie Whiskey on a silver Kia. I don't know this.
Now, this is easy to debunk also. Why? Because the officer is saying he doesn't know how many occupants are in the vehicle, but he does know that there's a driver, and that driver is not wearing a seatbelt. Why? Because he couldn't see into the back seat, and the windows are tinted. So when trying to relate how many occupants may be in the vehicle, he says unknown occupants. That doesn't mean there's no occupants in the vehicle. That means he just doesn't know how many there are. But he does know one thing. He observed the driver without his seatbelt on. And then lastly, we have to address the issue of whether there is probable cause to make this traffic stop. Now, LackLuster asserts that there is no probable cause to make this traffic stop.
These two facts eliminate all probable cause for the entire stop, which means everything that occurs after this moment was unlawful.
Now, let's say LackLuster is correct in saying that there was no probable cause for the stop. But then he goes and says that means everything that occurred after is unlawful. But you don't need probable cause to make a traffic stop as a law enforcement officer. You need reasonable suspicion. Here is the U.S. Supreme Court saying that, quote, accordingly, we hold, except in those situations in which there is at least articulable and reasonable suspicion that a motorist is unlicensed, or that an automobile is not registered, or that either the vehicle or an occupant is otherwise subject to seizure in violation of law, stopping an automobile and detaining the driver in order to check his driver's license and the registration of the automobile are unreasonable under the Fourth Amendment. Now, any legal book you look in, they're going to say for traffic stops, you need reasonable suspicion. The Supreme Court has deemed it. The Florida courts have deemed it. Everywhere you look, reasonable suspicion is necessary for traffic stops, which is a lower standard. The Florida Supreme Court has even ruled this. In this case, State v. Daniels from 1995. Quote, any police officer may at any time, upon reasonable cause to believe that a vehicle is unsafe or not equipped as required by law, or that its equipment is not in proper adjustment or repair, require the driver of the vehicle to stop and submit the vehicle to an inspection and such tests with reference thereto as may be appropriate. Now, LackLuster responded to my criticism and left a couple of comments in the chat. So this is what he said. Quote, while you're correct about the differences between PC and RAS, probable cause and reasonable suspicion, the two infractions cited by Officer Bowers meet the threshold for probable cause when observed. Reasonable suspicion is simply the minimum requirement for a traffic stop. He agrees. The examples you cited work well for the examples you choose, but apply reasonable suspicion to headlights during rain. If it's raining, the driver has no headlights, you don't have to be suspicious on whether they aren't using headlights. It's observable. Then he goes on to cite the two cases that establish reasonable suspicion is the standard that you need to pull over vehicles, not probable cause. I responded by saying the headlight infraction is a civil violation. Reasonable suspicion is the standard. It turned into a criminal infraction when he refused to get out of the car. LackLuster then responded again and said, I'm not sure what your point is. Reasonable suspicion is the minimum standard for a traffic stop. We all agree. Reasonable suspicion and probable cause are both standards in criminal and civil law. Agreed. Witnessing an offense is probable cause, i.e. witnessing no headlights, witnessing no seatbelt. I agree with that too. If an officer witnesses a person commit an infraction or a crime, they don't have to suspect that any infraction or crime was committed. Then after a little bit of talk about the live stream that I had earlier with uncivil law, he says, furthermore, probable cause is required to issue a citation, even for a civil traffic offense. So now let me read my response back to LackLuster. It says, I apologize. I should have clarified my earlier response better. Let me explain more clearly. First, reasonable suspicion alone is sufficient to justify a traffic stop. While you can certainly have probable cause, the court will specifically assess whether the officer had at least reasonable suspicion when initiating the stop. Having probable cause automatically includes reasonable suspicion, so if probable cause is established, then reasonable suspicion is satisfied. Second, you are correct that an officer witnessing a crime firsthand establishes probable cause. However, remember that for a traffic stop, you only need to meet the reasonable suspicion standard. It's similar to the legal burdens of proof. If I'm required to prove something by a preponderance of the evidence, but instead prove it beyond a reasonable doubt, I've exceeded the requirement, but the standard itself does not change. Additionally, probable cause is the minimum standard required for an arrest. Although a higher standard like clear and convincing evidence may exist, courts only evaluate the minimum standard required, in this case probable cause, was met to justify the government action. Now, when police went in front of a judge, the judge had to determine whether the stop was legit and whether there was probable cause to arrest Mr. McNeil. And when it came to reasonable suspicion, well, the officer said that he saw the driver without his seatbelt. That would be enough to satisfy reasonable suspicion. Then the second is that the officer said he observed the car driving in the rain without his headlights. That too would be enough to satisfy reasonable suspicion. Now, these two observations by the officers were enough to at least stop the vehicle and investigate further. So LackLuster is just incorrect by claiming probable cause is necessary to stop a vehicle. Now, LackLuster is so wrong, even the case that he cites stands for the proposition, but I don't think he's actually read the facts of that case. So let me give you guys the facts of that case. Wren v. the United States.
Wren versus United States. James Brown was driving his car with Michael Wren as a passenger. Both were young African-American men. They were driving in an area known for illegal drug sales. Police officers patrolling the area for drug offenses observed Brown and Wren stop at an intersection for an unusually long time. The officers became suspicious that the men were drug dealers. At that point, however, the officers lacked probable cause or even reasonable suspicion that the men were selling drugs. The officers continued to observe the men and eventually saw Brown commit some minor traffic infractions. The officers stopped the car and approached the driver's side. In plain view, an officer could see plastic bags containing what appeared to be crack cocaine in Wren's hands. The officers arrested Wren and Brown and searched the car as an incident to arrest, finding more illegal drugs.
And the court said this stop was okay because it was a traffic stop based on reasonable suspicion. Now, this is where I have to turn into law professor Nate. Let's talk about this probable cause and reasonable suspicion thing. So let's start with the Fourth Amendment to the Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing place to be searched and the persons or things to be seized. That's pretty straightforward. If the government's going to search or seize your property or even you, they have to do it by probable cause. It literally says that right here. And I need you guys to understand, it does not say reasonable suspicion here at all. So all seizures, all searches must be supported by probable cause. So now I know your next question is, are stops like a Terry stop for stop, question, and frisk, or traffic stops that require reasonable suspicion, are they seizures under the Fourth Amendment? The Supreme Court says yes, they are seizures under the Fourth Amendment. Here's what the Supreme Court said in Delaware v. Prowse, 1979. Stopping an automobile and detaining its occupants constitutes a seizure within the meaning of the Fourth and 14th Amendment, even though the purpose of the stop is limited and the resulting detention is quite brief. Now, I know what you're thinking. You're thinking, Nate, so if a stop is a seizure, then the Fourth Amendment says it needs probable cause. It says right there, unreasonable search and seizures shall not be violated but upon probable cause, right? It's there. But here is what the Supreme Court decided to do. They went with the spirit of the Fourth Amendment. Even though we have words written on this page, we're not going to treat all seizures the same. There are different types of seizures. There are some seizures, like the ones in the Fourth Amendment, that requires probable cause, but we're going to say there are other seizures that require reasonable suspicion, and we're going to just make that up. And they made that up in a case called Terry v. Ohio.
The one dissenting opinion by Justice Douglas. He strongly disagreed with the decision, saying, quote, "We hold today that the police have greater authority to make a, quote, seizure and conduct a, quote, search than a judge has to authorize such action. We have said precisely the opposite over and over again," adding, quote, "To give the police greater power than a magistrate is to take a long step down the totalitarian path. Perhaps such a step is desirable to cope with modern forms of lawlessness, but if it is taken, it should be the deliberate choice of the people through a constitutional amendment."
Now, courts do this all the time, and Supreme Court notoriously does it all the time. Now, you may hear someone say the spirit of the law, but what it's really known as is legislative intent. And the Supreme Court does this all the time. There is case after case after case where they've said, we're going to go with the spirit of the law rather than the text. As an example, in the case Church of the Holy Trinity versus the United States, the statutory text said the law prohibited assisting or encouraging migration of any foreigner under contract to perform labor. Now, the Church of the Holy Trinity hired an English minister, and the government was saying that violated the law because it was migration of a foreigner under contract to perform labor. But the court believed that Congress didn't intend for the law to be applied in this way. They declared that this wasn't the spirit of the law. Quote, "While there is great force to this reasoning, we cannot think Congress intended to denounce with penalties of a transaction like that in the present case. It is a familiar rule that the thing may be within the letter of the statute, and yet not within the statute, because not within its spirit, nor within the intention of its makers." So as you can see, from the Supreme Court all the way down to the trial court, the spirit of the law matters. So no matter what the statute actually says, the court will take into account the intent of the legislature.
The spirit of the law. Now, let's go to this traffic stop we're talking about. Let's look at Florida law and public safety. So Florida courts apply the same approach, especially when public safety is at stake. The Florida Supreme Court, the highest court of the land, decided this in State versus Egan, 287 South 2nd 1, Florida, 1973. And I quote, "Statutes enacted for the preservation of the public health or safety are to be construed liberally in favor of the public interest and to effectuate the purpose of the law." Come on, lead attorney, right? Because this is a Florida Supreme Court decision. It is what's called a binding opinion, a binding holding on all Florida courts, including the court that would handle any challenge to the Jacksonville traffic stop. Now let's apply this to the headlight statute. Florida statute 316.217 states headlights shall be displayed during, and that's what he kept focusing on, the word during, any rain, smoke, or fog. The word during is what the lead attorney tried to dissect literally, but that's the wrong lens. Under a liberal construction for public safety, the statute's purpose is driver visibility, and it comes first, not just for the driver, but for the public. The Florida Supreme Court would agree. That means whether it's heavy rain or a light drizzle, visibility is impaired. You don't wait for a meteorologist to certify it's raining enough. You turn on your lights because the point is to be seen and to see others. The statute doesn't exist to protect clever interpretations. It exists to protect lives.
Now, this turns me to the lead attorney, who says this.
The lawyer's point of view, because again, this is a legal case. We are talking about state statutes. I will tell you as a lawyer that when anybody says the spirit of the law, then you know you got them. When somebody has to retreat to the word spirit, it means that the arguments that they're making are not in the statutes textually. Or when you're in trial and you hear opposing counsel say, oh, well, that's the spirit of the law. That's what the legislature surely meant. I'm sure that if the legislatures had more time, then they would have said, they would have clarified, they would have put in writing.
In the case of the Holy Trinity versus the United States, the legislative would have said that this doesn't apply to preachers, but they did. And the court said, based on the spirit of the law, it does. Now, let me step back for a second so you guys understand what we're talking about. See, the big contention in the case of Mr. McNeil, who was beaten by those cops in Florida, was whether the stop was legitimate. Now, we've already discussed discussed the whole reasonable suspicion thing and how the court essentially made that up based on the spirit of the law. And I showed you some other examples of the court just saying, hey, even though the statute or the amendment says one thing, we're going to read some of the principles in it to make it work. Now, LackLuster and the lead attorney says, well, because when the car was pulled over, it wasn't raining at that particular time. That means the stop is bad.
Class, I am your professor, Professor Lead. Today we're going to talk about this case and whether the officer was allowed to pull the driver over because he didn't have his headlights on. And since you're a first-year law student, it's your first day of class, you might say, well, that's not really what they meant, right? They didn't mean during. No. The United States Supreme Court, all the way down to all the lower courts, have always said that the legislature means exactly what they've said. If the legislature would have wanted to write this law to say, before the rain, then the legislature could have done that. If the legislature wanted to say 30 minutes after the rain or an hour after the rain, the legislator could have wrote that in the statute.
If the legislature would have allowed searches and seizures to be done under reasonable suspicion, they would have put it in the Fourth Amendment. Now, as you can see, the lead attorney's argument falls apart when it's applied to the real world, the way the Fourth Amendment's been interpreted, the way other statutes have been interpreted. Even in Florida, statutes are interpreted based on the intent of the legislature. And I think it's important to know the lead attorney hasn't cited a case. He's making these legal conclusions without any support, as I am trying to give you support for each one of my legal conclusions. Now, let's transition to what the lead attorney's actually arguing for. He's arguing that the officers did not have reasonable suspicion to pull over the car because when they pulled over the car, it wasn't raining at that particular time. Here is his explanation.
All right, here is the state statute right here, the Florida Senate, the Florida statutes, when lighted lamps are required. But here is where we get into the thick of things. You are required to have your headlights on during any rain, smoke, or fog. So if I ask you, young student of mine, when in Florida are you required to have your headlights on? Relevant to this specific case, the answer is during any rain, smoke, or fog. You got that? Rain, smoke, or fog. So what does that mean? It means that the officer has to initiate the traffic stop during the rain. The officer has to pull this driver over while it's raining.
Did you catch that? The lead attorney was slick there. He added a whole bunch of other stuff to this statute that's not even there. And I bet none of you caught it. Where in this statute does it say that the officer must initiate the traffic stop during the rain? It doesn't say that at all. Listen to what he says again.
So what does that mean? It means that the officer has to initiate the traffic stop during the rain. The officer has to pull this driver over while it's raining.
Just for clarity, this statute only tells you about when you need to have your headlights on, particularly during any rain, smoke, or fog. Now, the lead attorney has added a whole other piece to it, a temporal piece, a part about time. The officer can initiate a traffic stop after observing those three things. You're driving, it's raining, and the headlights off. So during the traffic stop, it doesn't have to be raining. When the police officer initiates the traffic stop, it doesn't have to be raining. The law doesn't require anything like that. Just so we're all on the same page, there is no requirement that the officer must pull the car over while it's raining and the car has its lights off. That is not a requirement under this law. And it's funny because the Officer Tatum did the same thing when he was going over the statute. He essentially said this whole during any rain, smoke, or fog was during inclement weather.
If somehow it wasn't inclement weather, which means it wasn't raining at all, you wouldn't still see rain droplets on his car.
Did you catch it? Guys, I will tell you that if you are an attorney, you have to pay such close attention to every single word. What did Officer Tatum say? He said, if it wasn't inclement weather. What's the problem with that? The problem is inclement weather isn't a thing. It's nowhere in the statute. Guys, here is the complete statute that governs when your lights must be on, your headlights. Again, we see here during any rain, smoke, or fog. Do you see anything about inclement weather? As a lawyer, you have to pay attention to when people try to introduce new words, new meanings into an argument.
He's absolutely right. That's not in the statute, just like none of what he's about to say is in the statute.
So what does that mean? It means that the officer has to initiate the traffic stop during the rain. The officer has to pull this driver over while it's raining.
So now, let me just conclude with this. No, the cop doesn't have to pull the car over while it's raining. That is ridiculous. It's just like you have to say you have to pull the car over while it's speeding. That's ridiculous. The officer has to observe a traffic violation. He doesn't have to pull you over in the act. That's essentially what the lead attorney is saying. He's saying the officer must pull the car over in the act. That is not accurate. The law allows you to pull a car over after an officer observes the traffic violation. The officer observes the car speeding, then pulls the car over, and guess what? The car's not speeding anymore. The officer observes a car driving in the rain with its headlights off, and by the time the officer pulls the car over, it's not raining anymore. Now, this is criminal justice professor instructor Mike, and remember when he said this?
The Florida Supreme Court, the highest court of the land, decided this in State versus Egan, 287 South 2nd 1, Florida, 1973. And I quote, statutes enacted for the preservation of the public health or safety are to be construed liberally in favor of the public interest and to effectuate the purpose of the law.
Now, because I am an absolute sycophant, I went back and looked at that case, and what would you know? None of that was in there. I quote the case, that quote was not in that case. So then it puts me in a bad spot because now I'm looking up case law to see if this guy just made all this stuff up. But I was able to find the actual cases that stand for the proposition that courts will construe statutes liberally. For the first case, we got State v. Hamilton, 388 South 2D 561, 1980, the Supreme Court of Florida. Quote, a statute enacted for the public benefit should be construed liberally in favor of the public, even though it contains a penal provision. We also have City of Miami Beach v. Burns, 245 South 2D 38, 1971, Supreme Court of Florida again, and it has the same exact line. So instructor Mike was wrong with his citation, but he was correct with the principle. All right, so that was a long video, but I wanted to make sure I broke everything down as I saw it. Let me know how you feel about the situation. Tell me where you think I'm wrong. And don't forget to like, share, subscribe, do all that great YouTube stuff. I'm Nate the Lawyer. Peace.